This tutorial is to give kind of an overview of what we call secured transactions. Secured transactions arise under Uniform Commercial Code Article 9. Article 9 was revised just a few years ago, so all of the rules that apply to secured transactions are a little bit new and updated. A secured transaction is basically a transaction where someone is making a loan and securing the loan by using collateral. So we'll talk more about some definitions that go with those things. Now, first of all, if somebody, often a bank, wants to make a loan to someone else, they want to do what's called create and perfect their security interest in the collateral. So the first step is the creation of the security interest. And the steps here are basically that there's a couple options. One is that the creditor, the person making the loan, has possession of the collateral. An example of this would be a pawn shop. So if you take your watch to the pawn shop, give them the watch, and borrow money from them, they give you cash, they have the watch in their possession. That creates a security interest in the watch, which means they have rights to the watch when you default. The other option is that you have a written security agreement that explains who the creditor is, what they've loaned you money for, and it describes what the collateral is that they now have a right in. These are the transactions that are going to be more common with banks. If you think about, if you went to the bank and borrowed money and used your vehicle as collateral, you wouldn't actually give your vehicle to the bank. You would sign a security agreement that explained which car and that the bank has a security interest in your car. In order for the security interest to be valid, the creditor has to give something of value to the debtor. So a person can't just get a security interest in someone else's property, collateral, without having given them something. Usually in this case it's going to be a loan for some money. And the third one is the debtor can't give the bank rights to the collateral if the debtor doesn't have rights themselves. Now, it is possible that the debtor could have something less than complete ownership of the collateral. The debtor could have a partial ownership interest in the collateral, and so they would give that partial interest to the bank. Whatever interest they have can be used. Now, once we've met those requirements that we just talked about, the security interest has been created, and what we call that is attachment, meaning the collateral is basically now attached to that creditor, and that creditor can enforce the security interest. Now, a couple different kinds of collateral. These are pretty logical, they make sense. There's collateral that's tangible. These are the ones we usually think about. We've mentioned a watch, a ring, a car, maybe your piano. Those kinds of things are tangible goods. And then intangible goods are things like stocks and bonds, accounts receivable. Chattel paper is listed here, and interestingly enough, chattel paper is actually a security interest document. So that would be the security agreement that gives someone the rights to collateral. So that security interest could actually be pledged as collateral for a different loan. Okay, now, once you've created a security interest, sometimes the problem will become, I have a security interest in someone's wedding ring, say. But what if another bank also has a security interest in that same wedding ring? And what if that debtor defaults on payment on my loan and also defaults on the other bank's loan? Who gets the ring? So we have something called perfection that helps us to establish priority between the creditors. Perfection is usually done by filing something we call a financing statement. And this gets filed with the state, and it basically you can file the security agreement that we created before that says, I'm the creditor, I loaned this much money to this person, and they have pledged their wedding ring as the collateral, and this is the description of the ring, this is how much it's considered to be worth, so I have a description of what that is, and it's going to be signed by them to show that I have that security interest. Now what the filing does is it goes to the state and it becomes a publicly available record. So what that means is if the debtor who owes me the money and has pledged their ring goes to Bank B and asks for a loan and says, I will pledge my ring, Bank B will first do a search. A lot of times it's just called a UCC 9 search. Sometimes it's called a lien search. They will do a search and find out if that debtor has ever pledged that ring to anyone else. And the financing statement that I had the debtor sign will show up, and they'll be able to look at it and say, gosh, this ring is already pledged as collateral. We don't want to be second in line. We're not going to let you use that ring as collateral. Or they might say, okay, we can see that you only owe this other bank $500. The ring is worth $5,000. We'll loan you the difference. There are a couple of ways actually to perfect without filing. The first one is, as I mentioned before, like the pawn shop example, if the creditor actually has possession. And the reason that we allow this to be perfection is that there's some level of notice if the debtor doesn't have access to the collateral at the time. So if someone comes to me and says, I want to pledge my wedding ring as collateral to borrow money, and I say to them, okay, can I see the ring? And they say, well, no, I don't have the ring. The pawn shop has the ring. Well, that gives me notice that there is a perfected security interest out there already on that ring, and I need to realize that I might be second in line. The next kind of perfection that can happen without filing is called a purchase money security interest. Sometimes we just reference the acronym PMSI. This is where the creditor is the one who loaned the money to buy the collateral. So these kinds of transactions are really common. If you go to a furniture store and they provide financing, so you buy the furniture but you're not going to pay for it for a year and they're financing it, then the furniture becomes collateral and the furniture store is the creditor. Or you buy your vehicle and the car lot that sold you the vehicle is also financing the vehicle. Well, these creditors are in a superior position. Because you would not have the collateral in the first place, were it not for them, we allow them to have automatic perfection. And again, there's some ability to have notice. If you're telling me that you want to use your car as collateral on a loan, it makes sense for me to sort of ask the question, well, how is the vehicle financed, right? And is there a purchase money security interest holder on that vehicle? Okay, the next thing is, what does the security interest include? Well, obviously we can include things like a security interest in a vehicle, but in a business setting, when you think about consumer loans, you might pledge things like a ring or a car, but when you start thinking about more of a commercial setting, you're thinking about a business like Walmart borrowing money from a bank. And how does Walmart secure that interest? Well, they might do it through things like mortgages on property or other ways, but for collateral, they may want to pledge things like their inventory, and that creates some special problems because we know that inventory revolves. So if Walmart were to give somebody a security interest in their currently existing inventory, that wouldn't be very good for very long because the inventory moves quickly. So one type of security interest that we can use is called a security interest in proceeds. And this just says, if Walmart sells the item, my security agreement with them can say that I have a security interest in this currently existing inventory. When they sell it, I have a security interest in the cash that they get, the receivables, whatever it is that they now have in place of that initial collateral. Another way that we can use collateral a little bit differently is by putting in the security agreement. There will be a security interest in property that's acquired after the security agreement is executed. So a company might say, you know, right now they have cash or whatever it is they have. It could say that if they buy certain inventory, or if they acquire additional vehicles or whatever it is, we can put that in the security agreement, that will actually become collateral. In addition, we can add future advances. So on a continuing line of credit, we can say if you get additional money from the line of credit, that can become collateral. And finally, this is just another way to describe what we've been talking about. It's called a floating lien. So if you think about it, the concept is that sometimes we describe having an interest in collateral as a lien. I have an interest in the property. The lien sort of floats over changing property. And a good way to think about that, again, is with inventory. The inventory comes in and out. The lien floats above that inventory, even though bicycle number 1 that Walmart sold last month is not the same as bicycle number 10 that they sold. My security interest covers whichever bicycle happens to be in inventory at the time. Okay, now here's where this whole idea about perfection becomes important, is when we establish who gets what first. Okay, so the general rule is that when a debtor defaults and can't pay and the creditors have to start going after them, a perfected security interest holder is going to have priority over this whole list. Okay, so if a creditor has created a security interest by attachment and then perfected the security interest by one of the 3 ways that we talked about, either by possession, by being a purchase money security interest holder, or by filing the financing statement, that creditor will get first in line upon default over a creditor that's not secured at all, a secured party that has attached their security interest but did not perfect the security interest, somebody else who gets a lien later, some other kind of lien besides what we're describing here is a security interest in collateral. And there are all kinds of liens. One example is a mechanic's lien. Somebody who comes to your house and does work, they automatically have the right to put a lien on whatever it is they worked on. Or if you take something, your car, you take your car to the mechanic, have them work on it, they have the right to hang on to your car until you pay for it, until you pay for your work. So that would be a mechanic's lien. And if that lien happened after somebody already had a security interest in that car and that security interest were perfected, the perfected security interest holder would win out over the mechanic who is keeping the car to wait for you to pay for repairs. They also have priority over a trustee in bankruptcy. So when you go bankrupt and they seize all your property, the bankruptcy trustee would have to turn that collateral over to the person with the perfected security interest. And then finally, any buyer who buys the collateral not in the ordinary course of business. So this is particularly true if you were trying to get rid of the collateral to avoid paying the debt, okay? But if I'm a buyer in the ordinary course of business, so I'm just a buyer who goes to Walmart, buys inventory, and takes it home, I don't have to give whatever it is I bought at Walmart back to the perfected security interest holder. But if I'm, a person who's doing a deal with Walmart, and I go in and say, you guys are having some financial trouble, we'll agree to buy certain things, then I might not be in the ordinary course of business. Okay, now, what happens after that? Well, before we go there, let me just mention that generally we talk about the purchase money security interest holder as the sort of ultimate perfected security interest. They are usually going to be first in line over everyone else. So even over another perfected security interest holder. That said, let's just go down the line and see what happens. So if you have two perfected security interest holders, Bank A has filed a financing statement, so has Bank B. Well, whoever filed the financing statement first wins. They get to be first in line to take the collateral. Now remember that the purchase money security interest holder will take over both of those. He'll be first in line. Okay, the next one is if you have two unperfected security interests. So these are creditors who have created a security interest by attachment, but they did not file the financing statement, or they do not have possession of the collateral, or they're not a purchase money security interest holder. Here we just say, okay, the first security interest to be created wins out of those two creditors, first to attach. Obviously, before we go on, obviously the perfected security interest, we said before, has priority over the unperfected security interest. And then a security interest has priority over anybody else. Somebody who has borrowed money without putting collateral down, that comes after the loans that have been collateralized by security interest. Okay. Now, if the creditor decides to, at any time they can say, I don't want to have your collateral anymore, but for whatever reason, they have that right and ability to do that. They can also assign it, so they could take the contract, take the security agreement, and assign it over to somebody else. Then, of course, the parties can agree to change the financing statement at any time if they agree to do that. Once the debtor pays the debt that they're owed, the security interest has to be released at that time. And they file a termination statement so that now when someone does a UCC search to look to see what kind of financing statements are existing on that collateral, they find the termination statement that says, hey, this loan has been paid, so this collateral would be available again to back up some other debt. Now finally, how does this actually happen? Well, the Article 9 doesn't say what default is. You find out how a debtor defaults on the loan by looking at what the security agreement says. So the security agreement might say a default is when the debtor is a month late on their payment. It might say it's when they miss 2 payments in a row. It could say it's when they are 1 day late on 1 payment. So the security agreement will actually define what does default mean. So once the default has been triggered under the security agreement, then the secured party's rights kick in. And that's where they can, first they have the option to say, we don't want the collateral anymore. We're just going to try to go after the money if we can. and they'll go through a court proceeding to try to collect the money. A secured party might do that if the collateral has really devalued and it's not worth much anymore. They'd rather just try to see if there's another way to try to collect the money from the debtor. And the next option is they can go take the collateral. And there are a couple ways to do that. One is repo man, and that's where you've seen it in the movies. The guys, drive up in the night or whenever, and they go and they take the collateral. It's theirs. They have the right to it, as long as they do it in a peaceful manner. They can't do things like trespass or pull guns or do things that otherwise violate safety and peace. Or you can get go through the court system to have them do the repossession, and then the police will go and do the repossession for you. But that's going to cost you a little bit more. Now, once you have repossessed the collateral, you have a couple options. One is you can just keep the collateral and say, okay, this pays the debt. If it's a purchase money security interest and the debtor's already paid at least 60%, then the debtor can't just keep the collateral. Also, the debtor can object. The debtor can say, no, I don't want you to keep the collateral. I think it's worth more than what I owe you, so I want you to sell it so that I can see if I can get some of the money back at the end. So the debtor can say, I don't want you to sell. The secured party could also decide that they want to sell, that they would rather have cash. And that's probably the most common situation, especially with a bank. They don't necessarily want a whole bunch of stuff, they just want cash. So often this will be done at some kind of an auction. And the rule is that it has to be in a commercially reasonable manner. So what that means is, if you're going to have an auction, you've got to give public notice of the auction so that people can come and there's a chance of getting something close to fair market value. The bank can't just call the bank president's brother and say, hey, great deal. This guy only owes us $5,000 on his $40,000 truck. And, so all I care about getting is the $5,000. So why don't you buy the truck from me for $5,000 and it's taken care of. The bank can't do that. That would be not a commercially reasonable manner. Once they've gone through the process of making sure that they sell it in a commercially reasonable manner, now that doesn't mean they have to get fair market value. There's a recognition that the bank isn't going to go through the same process and steps that you might if you were selling your own car to try to get value. Which goes to the question, what should you do if you are in a situation where you are going to have to default on a vehicle or some other loan that has collateral? Probably what you ought to do is try to sell the vehicle, because you'll try to get more money for it than the bank will, and pay the debt. You don't want the bank to repossess your property. Finally, once they've collected the collateral, they can, what do they do with the money that they get? Well, they don't just get to keep it all. First, it goes to expenses. So they had to pay repo man, or they had to go through judicial proceedings to get the property back. Those get paid first. Next, whatever debt you owed, that gets paid off. Then, if there's money left, it goes to junior liens, and those are the other liens we talked about. So if there is a perfected security interest that was perfected later, an unperfected security interest, a mechanic's lien holder, all those people will get paid next. Then, finally, if there's money left, whatever is left over goes back to the debtor. So that's the basic story of how secured transactions work. If when you watch TV, you might kind of watch for people doing repossessions and see if it kind of matches what we've talked about.